a lot of entrepreneurs, they get their ideas and they start working when they are working for somebody else, another employer. And this can have a lot of issues, especially when you're spending so much time thinking about your employer's problems. A lot of new company ideas come out of problems that originated with their employer. Now, you have a duty of loyalty, just like an accountant has to his clients, a lawyer has to his clients. This is a special duty, and all of your time, all of your work product is kind of by default owned by your employer. So be careful when you're working on new business concepts that relate to your employer's business. Make sure that you make very deliberate choices as to when, where, and how you're working on your new business. Make sure it's after hours, on your own equipment. If you can, make sure that it doesn't even relate the concept to your employer's business, so that when you are ready to leave, there won't be any question when your employer sees your new business that he's going to come and say, hey, that's mine, I own that, give it back. When you are exiting, if you had an employment agreement in place at any time, go read it. Make sure there's no non-compete provisions in place. Make sure you understand what's going to happen when you leave. No time for that story, but employers can force you into situations that you don't like just because they can be bullies and threaten litigation. Back to the choice of entity. When you do go to launch your company, a lot of times, I know there's been branding guys here, and you choose your brands for many different reasons, but one of the things that branding experts may not tell you is to go and look and do a little research to see if your branding and your names are available. A lot of companies now will quickly go and do domain name searches, and they think, oh, well, the domain name's available, that's my name, I'm running with it. One other resource or one other place you should check is go to the United States Patent and Trademark Office site and search trademarks. It's uspto.gov. Do a quick search, a couple variations on your name, and see what's out there. If there are some similar names out there, don't hesitate to call me or another attorney that you know, an IP attorney, and say, hey, I found these couple other names. Should I be worried about these? It makes it can reduce a lot of headache than being in a situation when 4 years down the road and you've got revenue, this competitor who has, or not a competitor, but another company who has a similar trade name or trademark comes and says, oh, by the way, you're infringing and we want you to stop using it. And then you deal with headache of litigation or rebranding where you can solve those issues from the beginning by just taking a quick look at a few relevant databases. One way that you can really get a definitive answer as to whether or not you're going to have trademark issues in the future is to go ahead and register your trademark with the USPTO. It's a fairly inexpensive process. It's between $325 for registration fees to about $900 for registration fees, depending on how extensive your protection you're looking for. You can pretty much file it on your own out of the gate. If you do a good job, you may not have a whole lot of issues. And once you receive that protection, the USPTO is essentially saying to you, hey, if you get your trademark granted, they're essentially saying you're not infringing on any trademark that we know of today. There may be some common law issues out there where somebody registered with the state, but by and large, you can kind of move forward with a 99% surety that because you've received this registration, you're not going to get sued for trademark infringement down the road. IP too. The second reason that you have an entity, really, you've got this limited liability structure. The second thing is you've got kind of a vault in which to throw all your stuff. And all your stuff that you want to own is a lot of this with, we're a big tech startup community here, is related to IP. And the big startup issue of IP that happens is startup companies will hire an outside consultant to build some stuff, or a founder will build some stuff and then leave. Well, the default rule, if you hire an outside party, a third party, even if you pay them all this money for this intellectual property, if they don't sign an agreement saying that you own it, they own it. And so make sure you have those agreements in place. Do that with your employees, your consultants, and all founders. And last point, use an attorney wisely. Attorneys can be expensive, and you can rack up bills very quickly, but don't hesitate to use attorneys. If you've got a critical deal, a critical contract that's going to be important to your business, spend the time with an attorney. But be wise about it. Prepare them in advance with emails. Prepare them for phone calls. Do your own research and see what else is out there on the web that you can get, and then maybe have them take a look at and say, yep, you're on the right track. My name is Jared Richards. I'm with Bennett, Tueller, Johnson, Deere. We have the pleasure of working with young startups, mid-stage companies, and help on exits. Thanks for letting me present today.